Welcome, everyone. As Ben said, this is the second in a three-part series on nonviolent civil resistance, implications for international law and lawmaking. And this will examine the sort of intersections of civil resistance movements and international law. The idea for this series was developed originally as a project of ACIL's signature topic initiative in cooperation, as Ben said, with the ICNC, the International Center for Nonviolent Conflict. The first of the series, 2 weeks ago today, was called Nonviolent Movements for Democracy and Human Rights, the call from the front lines, and highlighted recent social science scholarship and practice on civil resistance movements. 2 weeks from now, we will have a third panel that will examine issues related to external support to democratic and human rights movements. And that will focus on relevant social science research that suggests what forms of external support most effectively contribute to these movements, and from the perspective of international law, the possibilities for the development of doctrine and thought about a right to assist that could be supportive of these kinds of contributions. Today's session will, I think, be fascinating in its own right, but also as a kind of natural bridge between the first and the third panels, 2 weeks ago and 2 weeks from now. If elements of civil society are increasingly engaged in nonviolent civil resistance efforts in their attempts to secure freedom and justice and the realization of their human rights, what are constructive ways to think about the legal and perhaps other principles that should guide the way we think about them? We're fortunate to have with us Professor Elizabeth Wilson, who has a law degree from Harvard and, more interestingly, a PhD in literature and literary theory from the University of Pennsylvania. She started her legal career working by becoming deeply immersed in litigation on behalf of Guantanamo detainees while working at WilmerHale, which once, many years ago, I worked at, and Bob Robinson and Lewis. Later, she taught human rights and international law at Rutgers, at Columbia, at GW, and at Seton Hall. In 2017, she traveled to India as a Nehru Fulbright Senior Scholar to study the work and legacy of Mahatma Gandhi, and she's now a visiting research fellow at Rutgers Law School Institute for Information Law and Policy. And Elizabeth first became interested in nonviolent civil resistance because of teaching a course on human rights during the Arab Spring, and has been working for a number of years on building a bridge between international law and nonviolent civil resistance studies. So we're anticipating that she will speak for, I'm not exactly sure, maybe 40 minutes or so to present an overview of her research and of these issues, and then we'll open up we'll ask some questions and open up the Zoom session to questions and answers. So without further ado, Elizabeth, over to you.
Thank you, Todd, and thank you, ACIL and ICNC for hosting this event. What I'm going to talk about today is, as Todd said, work I've done in international law and nonviolent civil resistance, which is primarily contained now in a monograph published by ICNC called People, Power, and International Human Rights, Creating a Legal Framework, a free download of which is linked at the digital flyer for this event. And if I can do these screen share successfully, I will pop up a quick image of the monograph. It's a meaty work, 150 some pages long, but it still doesn't contain everything that I have to say about the subject. So there are also two other relevant papers that I've written, one published in the Duke Journal of International and Comparative Law, and the other in the Journal of Human Rights Practice. So today I'm going to be giving a kind of executive summary of the work that I've done. And so there are some details, many details that I'll not be able to include, and that's why I'm giving these references. In particular, for reasons of time and because we have an ACIL audience, I'm not going to be talking about how international human rights law protects participants in nonviolent civil resistance movements and about the available mechanisms. That's in the monograph, and I refer you to it if you're interested in it. I'm going to put my emphasis on how nonviolent civil resistance challenges us to think differently, or we may think differently about some basic concepts in international law, like sovereignty, war and recognition, and particularly about international human rights. And before I go on, I'm just going to say that I'm using people power and nonviolent civil resistance interchangeably here, because nonviolent civil resistance is kind of a mouthful, and it's a little cumbersome to keep saying it over. So people power will be my shorthand. It might be good to begin by defining nonviolent civil resistance. This definition that I use is taken from Erica Chenoweth and Maria Stefan, who wrote the prize-winning book that was very seminal in my thinking, Why Civil Resistance Works. And this is the definition. Nonviolent resistance is a civilian-based method used to wage conflict through social, psychological, economic, and political means without the threat or use of violence. It includes acts of omission, acts of commission, or a combination of both. Scholars have I'm going to stop the screen here. Scholars have identified hundreds of nonviolent methods, including symbolic protests, economic protests, labor strikes, political and social non-cooperation, and nonviolent intervention. Nonviolent civil resistance takes place outside traditional channels and is distinct from other nonviolent political and legal processes, such as lobbying, electioneering, and legislating. Most of my discussion today is going to focus on international human rights law, but I'd like to start with a few very general and high-level comments about what taking account of nonviolent civil resistance might mean for international law more generally. And we'll start with the laws of war and conflict. Many of those who practice and theorize people power think of it not as a negation of warfare, i.e. pacifism, but as an alternative means of waging war, as war without violence, or as unarmed insurrection. Pacifism and even the noun nonviolence are terms avoided by some who study and practice nonviolent civil resistance, perhaps because they carry undesirable associations of passivity and weakness. Proponents emphasize that embrace of nonviolent resistance need not be principled, based on the belief that violence is morally wrong. It can instead be strategic, embrace because it is likely to be more successful. Thus, people power is often characterized as conflict rather than conflict resolution. And here are a couple of quotes from the literature. Those who use nonviolent action in our stories did not come to make peace. They came to fight. This is a technique of combat. It's a substitute for war and other violence. The parallels to warfare have even attracted military minds to promote and engage in nonviolent civil resistance studies. One of the theoreticians who makes the analogy between nonviolent conflict and war most explicit is retired US Army Colonel Robert Helvey, who has done trainings in nonviolent strategy for activists in Serbia and Burma, and written a book on strategic nonviolent conflict, thinking about the fundamentals. To Helvey, war is not an analogy. Nonviolent action, he says, is a form of warfare. And, quote, you've got to think of it in terms of war. So the principles of war that apply to a military struggle have tremendous overlap into strategic nonviolent struggle, unquote. Despite ambivalence about pacifism, though, a large part of the case for nonviolent action is that nonviolent conflict is morally, not merely pragmatically, preferable to violent conflict. Helvey advances nonviolence in part because of the reasonable likelihood that it will result in fewer lives lost and less destruction of property. I first proposed this series to Todd for inclusion in the signature topic of preventing mass atrocities because of recent findings by researchers that although mass killings commonly occur in the context of violent uprisings, popular uprisings, in authoritarian states, they are 3 times as common in violent uprisings as compared to nonviolent uprisings, occurring in 68% of violent uprisings as compared to 23% of nonviolent uprisings. In Syria, for example, protester deaths sharply escalated when the conflict turned from nonviolence to violence. Death tolls in Syria skyrocketed from 5 or 6 to 30 victims of regime fire per day in the nonviolent phase to 70 to 300 victims of regime fire per day in the violent phase. From data like this, It follows that if we want to prevent mass atrocities, we should be looking for ways to support nonviolent movements and to discourage violent movements. Given that both people power movements are increasing in number and that they are morally and pragmatically preferable to armed conflict as a means of resolving political disputes, the international community should be looking to develop a legal and policy framework to support and incentivize them. We have a large body of law governing armed conflict, but almost nothing on nonviolent conflict. This thinking could be part of how we build out the law governing non-international armed conflicts. We need to devise a set of rules that differentiate violent from nonviolent resistance movements and treat the latter as presumptively superior indicators of the will of the people. The right of peaceful assembly in international human rights law does not really address large-scale demonstrations that are aimed at removing one government and creating another, or throwing off one government and substituting another. I say a little bit more about this in the articles, but some preliminary ideas for this framework might be to give a privilege of nonviolence to those who engage in nonviolent conflict and successfully maintain nonviolent discipline. A privilege of nonviolence might also require treatment for nonviolent civil resistors comparable to that guaranteed lawful prisoners of war. But these are just a few initial thoughts. Turning now to the question of sovereignty, and this is probably the largest conceptual issue that I think people power raises for international law. It should be remembered that one of the original aims of the responsibility to protect, as outlined by the International Commission on Intervention and State Sovereignty, was to reconcile two notions of sovereignty: the international legal notion, which vests sovereignty in the state only, and the domestic notion of sovereignty, in which the people are the sovereigns from which power flows. So people power holds some implications for how we think about sovereignty, and may ultimately provide a foundation for seeing an expanded role for non-state actors in the formation of international law. Nonviolent civil resistance movements have, over time, demonstrated their ability to have potent effects on international relations worldwide, altering the geopolitical order in ways long considered the prerogative of states. In Central and Eastern Europe, nonviolent movements helped to bring about the fall of the Soviet Union and the reemergence of numerous independent European states: Poland, Czechoslovakia, Slovenia, Hungary, a united Germany, Estonia, and Latvia. Nonviolent civil resistance helped many nations win independence or end colonialism, as in India, Ghana, and Malawi. It played an important role in East Timor's independence and in ending Syria's occupation of Lebanon. People power, I would suggest, bears on the status of a state or government in international law in two different ways. Because the state is so reified in international law, it is often forgotten that people power created states. They did not magically spring full grown from the ground of post-Westphalian Europe, like Athena from the head of Zeus. They required the work of individuals and groups to create imagined communities, to use Benedict Anderson's phrase. The role of people power in the creation of states could be called front-end people power. Back-end people power is a term I use to refer to the actions of individuals and groups in systematically withdrawing consent from the existing government during revolutionary people power campaigns. And the central insight of civil resistance study is that all government rests on the consent of the governed, whether it is an authoritarian or a democratic system of government. But when this consent is withdrawn, the presumption that the government has the acquiescence of the population has been arguably rebutted. When ending the government gives rise to new state boundaries, back-end people power is in effect withdrawing consent from the state itself. So these are just a few preliminary thoughts, and there's more in that, particularly in the Duke Journal article that I mentioned earlier. So I'm now going to transition to talking about international human rights law, because that's where I've done most of my thinking, and that's what the rest of the talk is going to be focused on. As Todd mentioned, I first started thinking about people power and international law during the Arab Spring. Not since 1989 had there been such a cascade of nonviolent resistance movements in quick succession. Though many of them ultimately failed, their power was evident. At that time, I was teaching a course on international human rights to undergraduates and trying to think of ways to integrate the current events into the course. I was struck by how many of the Arab Spring demonstrators referenced Gandhi and Martin Luther King. I learned about the work of Gene Sharp, a major expounder of Gandhi, who has written some of the most extensive and practical work on people power movements, and how organizers were studying his work and circulating them. I found it perplexing that the human rights works I was teaching to my students had no references to, literally made no mention of Gandhi, yet he was such an inspiration to many who have advocated on behalf of human rights, not just in the Arab Spring, but well beyond that. So I began with the intuition that the tools of nonviolence, civil disobedience, non-cooperation, stayaways, demonstrations, street theater, could be thought of as a practice of human rights, that people power movements could be thought of as human rights in action. But for the most part, there was no way to take account of this in international law. The work is being done to conceptualize how non-state actors can be taken account of by international law, which is primarily, as we know, based on the relationships among states, and states are the only entities given lawmaking power. Thinking about non-state actors seems to me particularly critical with respect to human rights. I have argued that people power, the power of individuals and groups working together in an organized and non-violently forceful way, is the true source of human rights. And I call this a democentric approach. Paying more attention to the role of individuals in human rights law is more than just descriptively accurate. It recognizes that individuals are not merely passive victims of state and governmental action. They are also active agents that affect the shape of domestic and international law. In that way, a democentric approach respects human dignity. Aligning our accounts with international law, with the work of individuals and groups, will also go some way towards ameliorating the legitimacy problem in international law. So, for example, if we think about sources of law, I see that there's a contribution as to how nonviolent civil resistance can help sort out some conceptual problems relating to human rights. Whether you look at customary or conventional law, human rights presents a problem, both in terms of sources and enforcement. Looking at the treaties, it has been suggested that human rights treaties are in the nature of a special category within the general corpus of international law, and are therefore not subject to the usual rules governing application and effect. There is a sense that human rights treaties are not simply ordinary treaties, where human rights are merely the incidental subject of a contractual bargain between states. And this is because these treaties are premised on the idea that the rights that they protect pre-exist the treaties themselves. At the same time, the treaty framework is weak. If we look at treaties, many states have entered important and quite broad reservations to them, creating a patchwork of coverage. As well, most treaties have weak enforcement mechanisms, mostly limited to compliance oversight by independent committees. In view of the problems with the treaty regime, many scholars have turned to customary law for a generally applicable international law of human rights. But it has been clear that traditional customary law does not translate well to human rights. Traditional customary law, as we know, is created through a widespread and consistent pattern of state practice, undertaken with a sense of legal obligation, or opinio juris. Thus, in theory, we could only say that a customary norm of human rights had emerged when human rights were already being consistently respected in practice by the majority of states. This, we know, is not the case. Some scholars and jurists have attempted to overcome this conundrum by arguing for a distinction between modern or instant custom and traditional customary law, with the former placing less importance on practice, what states do, and more importance on what states say. Even states that torture don't say that they have a right to torture. They deny that torture is taking place. But modern custom has been criticized for weakening the notion of customary law and taking international law too far in the direction of utopia. To my mind, these difficulties with sources of law stem from the basic problem that international law derives from state action, while human rights in most accounts do not. In most descriptions, human rights are said to be inherent, belonging to human beings by virtue of their humanity. In his famous dissenting opinion in the Southwest Africa cases, Judge Tanaka of the ICJ put it this way: the existence of a human right does not depend on the will of a state, neither internally on its law or in any other legislative measure, nor internationally on treaty or custom in which the express or tacit will of a state constitutes the essential element. A state or states are not capable of creating human rights by law or by convention. They can only confirm their existence and give them protection. If human rights are inherent, by definition, they cannot derive from positive law or from state action. That is why they are often considered to be derived from natural law and given by God. This is problematic because natural law has fallen into disrepute owing to its historical links to Christianity, its subjectivity, and its apparent dependence on a theological foundation. The great positivist Hans Kelsen saw the natural law allusions in the Universal Declaration of Human Rights as defects, complaining that the declaration in Article 1 that, quote, all human beings are born free and equal, unquote, is a specific natural law doctrine that is far from being generally accepted. And he thought this placed the UDHR, quote, under the sway of a highly disputed doctrine, unquote. But this isn't the only way of thinking about international law. I believe that there's a way to make it more tangible, more concrete, and more like state action. And that is where nonviolent resistance movements come in. So I suggest that we look at natural law in terms that are more sociological and empirical, as normative demands being made by human beings, individually and in groups, as to what law should be. Before human rights were positive law, they were imagined natural rights, moral or political ideals that motivated social movements. For example, abolition, the fight for women's suffrage and equal rights, labor organizing, the movement to end child labor, to name a few. But the claims were more than simply political or moral. They were also demands for a change in law. In her book about the slave trade and the origins of international human rights law, legal scholar Jenny Martinez says, abolition was a social movement that had as its goal a change in society. But the change abolitionists sought was also fundamentally a change in law. Slavery and slave trading were legal, and abolitionists wanted them to be illegal. In rethinking natural law, I draw on the work of Robert Cover, who coined the term jurisgenesis to describe the creation of legal meaning by the nomos, or normative universe of different social groups within a society. Instead of an absolute term, something that exists eternally, independent of the mind of human beings, we can see natural law as a relative term that reflects a new world being imagined through the creative efforts of individuals engaged in the collective social activity of nonviolent resistance, where there is, or including civil disobedience, as in the famous case from the ancient world of Antigone, who refused to bow to the positive law of the land as to how she should respond to the burial of her brother. She claimed a higher law, and that is a very seminal example. Where there is no law or only bad law, human rights defenders have recourse to the tools of natural rights, civil disobedience, non-cooperation, boycott, stayaways, and so on. Moral rights become positive rights through different phases of jurisgenesis and are propelled by the acts of people, not of states. If we look at the history, the idea of human rights did not come into existence top down out of the benevolent intentions of states, even though states eventually began to recognize that large-scale human rights abuses could pose a threat to the international order. Rather, the idea of human rights came into existence from the bottom-up efforts of ordinary people in civil society to ally with each other in solidarity and demand their rights, often through organized nonviolent movements and campaigns. So recognizing people power points to another way of sourcing human rights. In his 1994 Sibley lecture, Lewis Hengen said that international human rights law draws its substance from national domestic laws, from national constitutional rights. If we look at the work of the drafters of the Universal Declaration of Human Rights, they studied existing national constitutions and other municipal laws from around the world as their starting point, looking to find patterns and consensus and drafting language that either reflected the best existing language or improved on it. But these rights provisions in national constitutions often resulted directly or indirectly from social movements engaged in human rights jurisgenesis. Take the prohibition against discrimination on the basis of sex. Women's rights were the aim of many national movements, which also collaborated internationally, that left visible imprints on their domestic constitutions. And many women's rights activists engaged in nonviolent resistance. In fact, Gandhi learned from British suffragettes how to deploy nonviolent resistance when he was observing them during the time he studied in England. US suffragettes demonstrated, refused to pay taxes, picketed the White House. When they were imprisoned, they engaged in hunger strikes, and they were force-fed. Susan B. Anthony was criminally charged for symbolically voting in the 1872 presidential election when women had not yet won the right to vote. In the speaking tour she undertook in her defense, she rejected the idea that government had the power to give or take away her rights. Quote, the Declaration of Independence, the United States Constitution, the constitutions of the several states, and the organic laws of the territories all alike propose to protect the people in the exercise of their God-given rights. The various women's movements in countries around the world then provided the raw material for the content of the UDHR provisions. So, in making an argument about the role of social movements more generally, there's a hesitation to look to such movements as a source of law because they can be seen as unruly or unbounded. If you unground law in this way, if it comes from social movements, doesn't that open up the possibility that you're saying might makes right and that rights are whatever people say they are? So there is a danger. And what we need to do is identify some limiting principles. Whereas Cover's idea of jurisgenesis was unbounded and available to all social groups, I tried to delineate the contours of a bounded jurisgenesis directed specifically to the realization of human rights. To do this, it's necessary to discover the narrative driving the genesis of legal meaning in that context. In the monograph, I just define the Human Rights Project as a legal, moral, cultural process aimed at creating and realizing a nomos or normative universe that is characterized by what I call the human rights ethos. This ethos consists of different iterations of a basic narrative in which the social ends of freedom, justice, and peace are imagined to be achievable through specific means, including the realization of human dignity through individual and collective activity organized around four general principles. These four general principles are non-discrimination, non-repression, non-exploitation, and non-violence. I derive them from readings of the major human rights document, and there's more on that in the monograph. These principles are heuristics. They don't represent a fixed state or defined substantive rights. They're more like vectors that define a direction along which human rights lawmaking activity can be organized. Oftentimes we don't need to avert to them because people power can be organized explicitly around rights recognized in international human rights law, such as when demonstrators in Hong Kong invoke the ICCPR. Let me see if I can do some screen sharing. Here. So there's a tweet from Universal Suffrage as a basic political right in ICCPR Article 25 that must be realized immediately. And there were numerous invocations of this in the umbrella movement and other iterations of that struggle. International human rights law can be overtly invoked in other ways, as when Egyptians organized protest times to coincide with Egypt's Universal Periodic Review at the United Nations. But when it comes to large-scale movements that have what Chenoweth and Stefan call the maximalist aims of throwing off an authoritarian regime or foreign occupier, it may be more complicated to discern a relation to international human rights law. That's because many of the objectives in such movements, democracy and end to corruption, are not currently recognized in human rights law or in international law more generally, which has striven to remain agnostic as to the nature of governments within the international system. So theoretical difficulties with custom or treaty law as an alternative source for general human rights law have led some scholars to turn to general principles, the third source of law identified in Article 38 of the ICJ statute. I use this source of law in developing the model that I use in the monograph because it remains unsettled doctrinally and leaves scope for innovation. A review of the relevant literature, which I do in the monograph, reveals at least 6 distinct approaches to general principles, ranging from a purely domestic law approach focused on identifying features common to the main legal systems of the world, to a purely natural law approach that seems to be intuitively grasped or is said to reflect a common conscience. This methodological muddiness seems deeply built in because the language of Article 38, general principles of law recognized by all civilized nations, was a compromise negotiated during the drafting process between those advocating for a natural law approach and those insisting that general principles derive only from domestic law. But that dual law, positive law feature makes general principles useful for describing human rights law. Since general principles are not defined purely in terms of state action, nothing precludes them from incorporating the actions of non-state actors as makers of law. While general principles are often used to fill gaps in international law, nothing limits them to procedural doctrines. And they're also useful for my purposes because they have a hybrid structure. 25 years or so ago, Philip Alston and Bruno Simma made a case for general principles as a source of international human rights law in an article where they subjected the idea of modern custom to a devastating critique. Although they pointed to UN practice as the place where general principles emerge, I think it is important to look at both international and domestic law and at both state and non-state actors. Methodologically, a general principles approach to international human rights would have some similarities to regular customary law, except that it would give significant weight to the activities of people power movements reflecting a human rights ethos. Inclusion of people power as a source of general principles of human rights does not dispense with the effort to create a consensus among states around binding human rights norms, but it supplements that effort with recognition that human rights norms have emerged from the bottom up. Through more detailed study of how the discourse of rights functions in civil resistance movements, we can begin to codify an international law of human rights based on the relevant practice of states, international and supranational organizations, plus the beliefs and expectations of individuals, as well as the people-powered practice through which the agency of individuals is organized towards the realization of the rights they are asserting and claiming. And I should note here that I do use general principles in two different ways, in a general sense and a specific sense. So the general sense that I'm referring to is as a source, an alternative source of law to customary law and conventional law, in which I'm developing a model. But the specific sense refers to the four general principles I identify as characterizing the human rights ethos. And so it's just important to keep that distinction in mind. So in building out a hybrid model, I'm going to pull up some slides again. I think of it as a hybrid, having a hybrid structure that involves both international and domestic law, and natural law and positive law. Natural law defined in sociological terms. So first, there's the recognition that human rights have both an international and domestic component. As long has been recognized by practicing human rights lawyers, the most effective means for enforcing international human rights law is to ensure that it is incorporated into domestic legal systems. But there is also bidirectionality, as I already discussed regarding the drafting of the UDHR, which continues to this day. For example, although no human rights treaty was originally interpreted to mean that states were obligated to enact a Freedom of Information Acts, after the number of states having domestic freedom of information laws rose from 30 in 1993 to 112 in 2012, the human right to free expression was now requires states to have a FOIA or the equivalent. Next, there's a recognition that human rights law encompasses both natural and positive law. Reference to natural law is necessary in theorizing people power because the positive law does not encompass all the rights that could be and have been claimed by civil resistance movements. The Declaration on Human Rights Defenders, for example, makes no mention of self-determination, of national or political liberation, no mention of democracy, or of a right to an accountable government. Yet these are often precisely the objectives pursued by civil resistance movements. Now, if we superimpose these two boxes on each other, we get something that looks like this. Box A in the upper right-hand quadrant represents the positive law of international human rights, protecting all human beings, which includes customary law, conventional law, and the institutional human rights mechanisms that enforce them, the Human Rights Council, treaty bodies, and regional human rights courts. Box B in the lower right-hand quadrant represents the domestic legal counterparts to international human rights law, including constitutional and bills of rights provisions that were incorporated in the UDHR, laws and statutes implementing international human rights norms into constitutions after the UDHR, and any relevant domestic legal enforcement mechanisms, such as courts, national human rights commissions, executive orders, and administrative processes. Box C in the lower left-hand quadrant represents natural law, defined as including the civil resistance movements that are organized primarily domestically and can be aimed at realizing human rights in those domestic systems. This can be like pressuring states as a kind of enforcement, another enforcement mechanism to implement or to international human rights law into the domestic legal systems. But it can also include movements for governmental accountability and resistance to oppression. Box D in the upper left-hand quadrant may overlap to some extent with social movements described in Box C, but it more specifically designates civil resistance movements having goals that potentially impact the shape of international order, like secession movements or revolutions to throw off foreign occupations. Nonviolent civil resistance that result in democratic revolutions or transitions overlap Box C and D. They are technically considered internal under current international law, but governmental change also affects the international order by changing the balance of democratic to non-democratic states. And this ultimately affects the kind of international law that will be developed in the future by the international community. So maybe I should pause there and say that's a chunk. Maybe we can have some questions either from Todd or from the audience.
Both. Thank you. Please, there's a lot there to think about. There's a lot of to digest. Please shoot questions through the Q&A function, and we'll try to get to as many of them as we can. And I was going to start with a question that I think the gist of the question is that the sort of reliance that traces back to the ideas of natural law is sort of a tricky thing. People in different countries have different backgrounds and may have very different senses of what natural law is. And it may be helpful if you want to talk a little bit more about sort of the methodology that you would apply. How should we identify what the natural law is? We look at all this stuff happening. How do we sort of identify what is the natural law that we're drawing from?
Right. So I continue. I mean, you could, as part of that kind of question, you could ask why retain the use of natural law at all. And I think it's useful to try to do so because it brings along a lot of the existing frameworks of international law, but sort of reconceptualizes them. So I think that, so natural law is kind of like a placeholder. And I'm suggesting instead of like God, that we fill it in with, looking at people power movements that further these broad aims of the human rights movements as it has developed over time. And clearly it's going to be tricky to devise an inductive process for determining the input of people power movements. And this will require close collaboration between legal scholars and social scientists that are studying civil resistance. But this work is already being done. Already empirical research in legal studies is being done on human rights in general and focusing on the impact of treaty ratification on the human rights behaviors of states. Arguably, civil resistance movements lend themselves more readily to empirical research than other human rights violations because such movements have many visible markers, whereas human rights violations are often carried out in secret. Large protests or strikes, or even consistently recurring smaller protests, street theater, flash mobs, are observable, especially in today's world of cell phone and social media access. So the quantitative work that has been done already by Chenoweth and Stefan shows that people power can be operationalized. Chenoweth and Stefan study what they call maximalist campaigns to create a database called the Nonviolent and Violent Campaigns and Outcomes Dataset, where they define a campaign as a series of observable, continuous, purposive mass tactics or events in pursuit of a political objective. And they've been continually updating and refining this database, and it has been being used with growing frequency by other social scientists. They're also developing other databases, and I think will be a collaborative effort going forward between legal scholars and social scientists to develop a more precise methodology. Some of those data sets are not looking, or well, most of them are not looking at these campaigns through the lens of international human rights law. So that would be something that legal scholars would have to bring to the table, and there would have to be, added to the analysis, the extent to which those movements should be considered as reflecting an ethos of human rights. So, for example, there's a wide variety of evidence that you could look at in evaluating whether a people power movement should be classified as furthering an ethos of human rights. And this could include publicly articulated motives for coming together and resistance, philosophical reflections and statements by movement leaders, movement signs, placards, banners, slogans, songs and poetry, movement educational materials and trainings, and even opinion polling that asked participants about their perception of the movement. Let me just pull up a couple of slides again. Where's the screen share? There it is. So here are a couple of images that I include in the monograph. On the left, some graffiti from the Czech Republic that says in Czech, Havel to the castle. So I analyze Havel's work, which was circulated in underground samizdat literature, to understand the extent to what he was standing for, what he was understood to stand for in that people power movement. On the right-hand side is some graffiti from the Arab Spring movement, and I traced some of the slogans that circulated during that period of time. Freedom is kind of it's not too difficult to see within the human rights framework, but the next image is a little bit more ambiguous or countervailing, and looking for evidence of a violent intent would undercut the claim that a movement was totally nonviolent. In the end, I found this piece of art more symbolic than indicative of a violent intent, but it's an analysis that would need to be carried out. Does that help to clarify?
I think so. Let me read some of these questions here. Why is recourse to natural law required in affirming a right to resist if it's already rooted in positive international law, both treaty and customary law? It's recognized in the colonial context, in the Friendly Relations Declaration, the definition of aggression under Resolution 3314, and under the African Charter on Human and People's Rights in Article 20. Why do we have to have recourse to this?
That's a good question, and my answer is that it's not specifically understood in the context of human rights, and so there's a
political resistance.
Sorry?
We're like political resistance and human rights resistance.
Well, yeah, it's just not in the existing framework of international human rights law. These are outside of the framework, and I think it is somewhat debatable about whether that makes sense or not. If you look at the Declaration on Human Rights Defenders, for example, you won't find any reference to those kinds of rights as being recognized in the furtherance of in the kind of activities that human rights defenders are entitled to engage in the furtherance of human rights. So there is there are different locuses for which these rights are maybe recognized in international law, and I'm arguing that they should be seen in terms of the human rights framework as well.
Thanks, Elizabeth. This is partly my question and partly a question from the audience. The question from the audience is, what's your opinion about situations where nonviolent resistance is simply not possible because of the violent suppression from the government? Is there then a right to rebellion? And I had, it's not the same question, but it's in the same area, kind of. When you were talking, I was thinking about, you were saying how this interest of yours began sort of following the Arab Spring, in the wake of the Arab Spring. And of course, the Arab Spring was largely a failure, right? It didn't really sort of produce what it was supposed to produce. And what should we learn by that? Did it not count as an expression of people power? Or, I mean, what lesson are we supposed to sort of draw from that? Which I think is related to the question of what happens when, resistance proves futile.
Well, let me answer the question about the first part of the question, because that's an important point, and it goes to a lot of the misconceptions that people have about people power movements. But this is really the product of the work of the social scientists. I mean, that was the result of the very thorough study that Chenoweth and Stefan did, that they found that these people power movements do take place in very oppressive and authoritarian societies as well, and that they can succeed under those circumstances, even so. The traditional, there's a kind of cliche that says, well, nonviolent resistance would not have worked against Hitler. And the answer that I've seen the researchers give on this question was that it really was never systematically attempted. So we don't actually know. There were some small scale nonviolent protests that had limited effects, but we don't know. But the research finds that even in very authoritarian regimes, that there can be successful.
There can be successful, but even in your statistics, I think it said there was a percentage that was successful, which meant that there was a percentage that was unsuccessful.
Sure. I mean, they're not 100%. They're not 100%. They're still probably more likely to fail. Although I think the original study found, I think that they were slightly more than 50% more likely to succeed. But there's still a large amount of time that they fail.
Right. So what do we learn by the scientists, and what do we derive from the fact that the people pushing for this particular right have been suppressed?
Sorry, can you say that again?
This group of people sort of clamoring for this particular right, whatever it is, this particular human right, have been suppressed and have failed to sort of gain recognition of it. Is that evidence that the right doesn't exist?
Well, I think there is research that shows that even a failed nonviolent protest movement can have positive effects down the line on a society. And I think that there is, I'm not a Middle Eastern scholar, but I have read that, nonviolent resistance is not just ad hoc spontaneous demonstrations. It's a very complicated and can be a long-term strategic process that involves creating alternative institutions, educational institutions, alternative markets, alternative cultures. And I've read the criticism that, at least in some of the Arab Spring countries, there was a more, a tendency to go too quickly to achieve a certain goal. And particularly in Egypt, there were two phases to that people power movement. There was the first transition, and then the second one that brought in al-Sisi. And in that second phase, it was not a pure people power movement, because the demonstrators or the organizers colluded with the military and actually acceded to the military's taking a leading role in that transition, which is a dangerous, a dangerous way to go. What you want to try to do with the military in terms of the theory of nonviolent practice is to draw the military away from the power centers and not to try to mobilize the military on behalf in itself to take power from the power center. Does that make sense?
Yeah, can I ask what maybe a follow-up question or maybe a different question? I sort of understood part of what you were saying to, there's a social contract kind of thing and there's consent, and that's implicitly there's consent, and that's why the government has the right to or represents me under international law, and the consent can be withdrawn. So to get back to this example, when the movement, in those cases where the movement fails, should that be seen as a statement that the effort to withdraw the consent failed, and that those people don't get their voice echoed in the sort of international space where this law is being formed? That was a long question. Sorry about that.
No, that's okay. I think that the answer is that then you would have to empirically examine, the reasons for the failure, and particularly the degree of participation in the nonviolent movement. That's one of the salient findings about the social scientific research about nonviolent movements, is that one reason that they succeed more often as opposed to violent movements is that they are able to attract a much broader swath of the population to support them and to engage with them. So I think the barometer would be, what is the engagement of the general population with this movement? If it's really broad and sustained, but it still fails, that would be an indicator that consent was being attempted to be withdrawn, and probably had been withdrawn, but it's just not being recognized by the government. Whereas a more limited and narrower kind of rejection of authority, like just happened in the U.S. Capitol a few weeks ago, would be
Doesn't count.
Sorry?
Doesn't count. But
well, it would not be as strong evidence to be weighed into the equation.
Mm-hmm. There's one question here that I was going to answer, which was, will the recording be available to attendees? This is the kind of thing that I can answer, which is yes.
Okay.
I think it's on YouTube, but it'll also be linked to the ASIL's website, and I think it will be on the also the website, which is an ASIL website, also the Atrocity Prevention Signature Topic page. I wanted to be able to answer at least one question, so that was the best I could do.
Can I say?
Yeah, go ahead.
I was just going to say, could I say a little bit about some thoughts about how other ways in which nonviolent actors might be seen as lawmakers?
Yes. That was one of the questions. Yes, that would be great.
Okay, so in the monograph, I explore three ways, and all of this is very, it's exploratory and kind of, there's a bushwhacking nature to it, but I suggest three ways that international nonviolent actors could be seen as contributing to the development of international law. And I'll present them in the order of how they radically depart from existing understandings. First, where customary law is still developing and where state practice alone might be inconclusive, a widespread pattern or practice of nonviolent movements might supply evidence of opinio juris, supporting the emergence of a customary norm. State practice induced by people power movements might supply this sense that a practice is legally required, that the state action alone might not be seen as having. And in the monograph, I look at a couple of instances of demands for transitional justice that were not necessarily considered as meeting the criteria for as being done because they were seen as legally required in international law, but they were done in the context of people power movements, which were demanding them as a kind of necessary right. Second, there can be situations where international human rights law does not recognize a particular right, but a contrary understanding is held by participants of people power movements. So, in that case, the views of the people, I argue, should have some weight, especially when there's a widespread and consistent pattern of behavior and actions that reflects the understanding. And the example here is the case of corruption. There's a dissonance between the international legal community's view and more grassroots view that is driving the proliferation of people-powered anti-corruption activities worldwide. International human rights law doesn't recognize a right to be free from corruption as a freestanding human right. And so corruption is characterized as a criminal matter. But activists on the ground often do see it as a human right and engage in nonviolent resistance activities on that basis. So there's a kind of a disconnect that I think is worth considering. In the monograph, I talk about the work of legal scholars who make the argument that the right to be free from corruption should be recognized as a human right, and argue that they can look to the activities of people power movements as support for their claims. And third, and most radically, I suggest that people power movements, if mobilized on a sufficiently large scale, are a different sort of sui generis source of law. And when they reach a certain scale and intensity, I would argue that they are activating the dormant social contract and withdrawing their consent from governmental authorities. And sort of my thinking here sort of engages with the fraught question of whether there is an international right to democracy. Despite a flurry of activity around the years after 1989, there has not been a coalescence of this as a strong international norm. But I would argue that when you have a broad-based people power movement and you have the consent that is being, visibly and withdrawn on a widespread basis, then you have an assertion of a kind of inchoate right to democracy that should have some recognition in international law.
I say you anticipated. I had a question that was joined to one of the questions of the audience, and the part of it that I think you just answered or addressed is, wouldn't a lot of this be explained if you infer that there's a right to representative government, which is a version of a right to democracy? The question from the audience is a little bit, is I think intellectually sort of related to that. And it says, I'd like to hear the answer to the second part of the question previously, which is whether there is a right as a right to rebellion. In other words, why are you arguing for a right to nonviolent resistance instead of the right to resistance?
Well,
what does international law care that it was peaceful?
What? Okay, so what does international law?
What does international law affect different because the resistance was nonviolent as opposed to violent?
I think the answer to that is that there are certain benign effects that flow from organizing a successful nonviolent resistance movement because it is dependent on maintaining what they call maintaining nonviolent discipline. And that is the refusal to engage in violence or the threat of violence and to respond to violence with violence. And this is not easy to do. I'm here to say it's not easy to maintain that discipline. I mean, to invoke a current example, I mean, we are seeing a lot of, I would argue, collateral damage being done by the persistence of very small groups on the left that have, are asserting today in the United States a right to engage in property damage and looting. Not a right, but the technique of engaging in property damage and looting as an asset in their struggle. But backfire effects are they work both ways. They're sometimes when the government, it can backfire on a government when it uses violence, that it magnifies the response. It draws more people out than would have come out before the acts of violence. But it can also backfire on the use, on protesters or demonstrators that are using violence. And we've seen, that small acts of violence get magnified and they capture publicity, and it enables the government to try to dismiss them as extremists or dangerous. This is happening, right as we speak in Russia at the moment. And so I think, there are people are going to have political conflict. Political conflict is going to take place. So so if we acknowledge that fact, then it makes sense to try to encourage people in the path of nonviolent resistance, I think, than in violent resistance. Does that answer your question to some extent?
It gets to it, yes. Can I, there are actually several more questions here, but we have, 3 minutes left. So there were great questions, actually, for which we are very appreciative. But I wanted to, if I could, take the last 2 minutes for you to just, I advertised this at the beginning as a link to the third section about the right to assist or the right to receive assistance. And I was wondering if you could just, to whet the audience's appetite for the third panel, if you could talk about that a little bit.
Sure. Although I just noticed one question that is asking about verbal violence as opposed to physical violence and the internet. That's a really great question, and I haven't addressed that in terms of this body of work. But in a previous life, I did some research on child abuse and looking at the way in which verbal and emotional abuse there was research that showed that was often as dangerous or more dangerous and harmful to children than physical or sexual abuse. And but it's not recognized as such. So I think there is something there. I just haven't been able to address that in terms of this current body of research. In terms of next week's panel, I just wanted to say that there is a strong foundation in international human rights law to support the idea of assistance to nonviolent civil resistors who are peacefully engaged in human rights. This support may include a variety of resources in addition to funding, such as training programs or educational materials. And these rights have been reaffirmed and given broad interpretation by relevant bodies such as the Human Rights Committee and the UN General Assembly and UN Special Rapporteurs. I go into this in exhaustive detail in the article in the Journal of Human Rights Practice, and a version of that was also published in a book edited by Maria Stefan, Is Authoritarianism Staging a Comeback? Where I examined the laws, the increasing use of law by authoritarian governments to try to strangle and cut off civil society, and how should external actors look at these laws. So it follows from the grounding in the right of the right of free association, that it's situations where states have passed laws restricting civil society organizations from associating with foreign supporters, non-state actors are on a sounder legal footing than states in disregarding such restrictive national laws, because they, unlike states, are not subject to the rule of non-intervention. And also because, unlike states, they are the rights holders of the relevant human rights. So external aid to nonviolent resistors, I think, would preferentially come from non-state civil society actors. But this technical legality of this aid needs to be weighed against whether it's pragmatically possible, and against the protections of immunity that may be available to state actors instead. So civil society and their domestic and foreign supporters may be subject to domestic or criminal or civil penalties, and so may foreign agents who are trying to support them. Sorry, something's going off. So that has to be weighed into the equation pragmatically.
Well, I think, I'm not sure what that buzzer was, but
that was
might be the 215 buzzer telling us we're going to pay like for satellite or something.
Yes.
I think we need to end it there. Thank you so much. This was really, really interesting. This really could easily be three sessions by itself, more for a semester or a course or several courses. It was really fascinating and informative to me, and I hope to the audience also. And I encourage people to tune in again in 2 weeks to hear the third of the series, which is about these issues of external aid to nonviolent movements. So, Elizabeth, is there a last thing you wanted to say?
There is the last. I just want to put up my email address in case people want to write me with questions. Yeah. So there it is. Can you see it? eawilson119@law.rutgers.edu.
Okay. Leave it up there for a second. And with that, thank you, everybody. And we hope to see you again in 2 weeks.